to avoid a denial in your marriage adjustment of status case. In this video, we will be covering denials, specifically how they happen, why they happen, and your options if it does happen. And make sure to watch to the end because we will be sharing some real-life examples and very common scenarios so you can avoid making those same mistakes. Look, while no one wants to consider the possibility of receiving a denial, it is something you want to make sure you're prepared for before you or your lawyer submits even a single form to the USCIS. Around 15% of marriage cases are denied every year, and while the majority of cases are approved no problem, denials can happen, and being prepared is the best way to navigate this process as efficiently as possible. Which is exactly why we guide our member couples through every possible situation from green card to naturalization inside our marriage immigration method program, so they're prepared at a moment's notice. So before we break down what happens if you get a denial, let's cover what is a denial, how do they happen, and what are the common reasons for denials. A denial can happen for many reasons, which we will cover in a second, but receiving one essentially means that the USCIS evaluated your application and decided you were not eligible for a green card. And this is very important because the USCIS did actually evaluate your case. They will not return your filing fees if they end up denying it. It's kind of obvious, but still important to note since that's the main reason why you want to handle it right and on the first try. No one wants to pay those filing fees twice, right? With over 130,000 denials in 2022, that equates to over $250 million in filing fees the USCIS retained. Now, that's not to say that every denial was erroneous, but the USCIS is a large organization dealing with a backlog of over 4 million cases, and errors definitely happen. So then how do denials happen? The first way is by receiving a request for evidence or RFE and improperly handling it, or the USCIS not accepting your response. RFEs are the USCIS way of letting you know that there are issues with your case or application that prevent them from approving your case. To overcome an RFE, you or your lawyer will need to respond and the USCIS will need to accept your response. If they don't, that leads us to the second way a denial can happen, and this is through a notice of intent to deny. Also called annoyed, you can receive one of these by failing to adequately respond to an RFE, or you can actually receive one of these right away without any RFEs. Annoyed is essentially what it says it is. It indicates that a petition does not have enough evidence to support your request for immigration benefits, and the USCIS intends to deny your request. And while annoyed is not an official denial, it does give you only 30 or 33 days to submit the requested documents or your case will be denied. So now that you know how denials happen, let's break down the common reasons for denials. First, you could get a denial because you don't qualify or are ineligible to apply for the marriage adjustment in the first place. It happens very often. To understand whether you qualify or are eligible, you should 100% check our mini course where I go deep on eligibility and you will learn a ton about forms, filing fees, etc. You can find the links under this video. Second, as we mentioned above, you either missed your response deadline for your RFE or the USCIS did not accept your response. Third, it could be a USCIS error. For example, they lost your documents or they simply claimed that they never received your response to an RFE request. Unfortunately, that one is a very common one. I mean, the USCIS can get intense, okay? So literally, you submit your response online, the status changes to your evidence was received or whatever, and you can even see your evidence online, and yet they still have the audacity to say that they never received it. And that's when you need to decide, okay, am I fighting with them on this one? Am I refiling or what am I doing here? Fourth, there were errors or mistakes in your application such as failing to provide translations of documents, submitting incorrect filing fees, issues with signatures, missing pages, and more. Missing pages is a big one. Your file will be huge and you will go over it a few times, so it's easy to accidentally lose the page or forget to sign and date the form. More often than not, in these cases, you will get an RFE and you will be able to address this with the USCIS, no problem. But then again, sometimes they just erroneously deny the case and then you have to fight with them to reinstate the application since it was their error. And even fifth, you failed to provide enough bona fide marriage evidence to establish your legitimate relationship. In these cases, the USCIS would normally issue an RFE or a notice of intent to deny instead of outright denying the case. Either way, to avoid this one, you can grab our free marriage evidence list in the description below. And alternatively, you can apply to our marriage immigration method program. Having gone through this process first and then becoming immigration lawyers, we know how difficult it can be to find the right help, and we know that the process is very much emotional and obviously highly important to you both. If you want the full game plan to ensure your immigration gets handled properly and on the first try, Schedule a free strategy session with us today to see if our program is right for you. Our link is in the description below. Now, going back to denials, it's important to know that if you were to get one, you're not actually without options, okay? So let's cover the two options you have and what they entail. First, you might not be able to appeal the decision, but you will be able to file a motion to reopen or a motion to reconsider using Form I-290B Notice of Appeal or Motion. You will have to submit that form within 30 days from the date of the denial notice. In our experience, those are rarely successful since no one wants to admit that they were wrong and create an undesirable precedent, and that's why those can be hard to win. Either way, you would need an attorney for that one. That means paying additional legal fees, paying USCIS appeal fees, spending time working with a lawyer to prepare this notice of appeal, and waiting an additional 6+ months while your appeal is being reviewed. And truly the worst part is that these appeals are very rarely decided in favor of the applicant unless, of course, it was a clear USCIS error. This is big because they also don't want to get sued, so when it comes to their mistakes, especially when you work with a competent attorney, you can win those. Not like many of us have the means to sue the USCIS, pay all the attorney's fees, etc., and they also know that. Either way, if you attempt to handle Form I-290B yourself, your chances are very slim. So, while appeals are an available option, they're not always the best approach for immigrant couples. This leads us to the next option available, which is to refile your case. Yes, that means paying the USCIS filing fees again and starting the process all over again. However, this can be a better option for a few reasons. Number one, you save all the resources and time required for an appeal, which could possibly not result in a positive outcome. Number two, you already have a completed application and understand where the weaknesses lie that led to the denial in the first place. Also, money is often a consideration in these cases. Let's imagine you submitted your application, everything was good to go, but then the USCIS erroneously issues a request for evidence saying that your sponsor does not qualify to be a sponsor, even though they clearly qualify. From there, you respond with that same information and your case erroneously gets denied. What do you do in that case? Well, first of all, your I-130 will most likely get approved and only your I-485 will get denied. But the consideration becomes, okay, so do I hire a lawyer to fight this, pay a ton of money to an attorney, file and pay for an appeal itself, since Form I-290B has filing costs associated with it, and then obviously wait for some time, or do I just refile the I-485 with a new filing fee and move on? But as far as the third reason goes, why it might be better to just refile is because you've now got more experience, which is an advantage when going through this process because you understand what's happening and what's required of you to achieve a desired outcome this time around. Another interesting example of a case I saw, this person self-filed his case without any assistance and he submitted a copy of his birth certificate without the translation. He just wasn't aware of that requirement. The USCIS issued an RFE asking for a translation, but he again submitted the actual birth certificate but without a translation. From there, the USCIS denied the case. I mean, it would be somewhat silly to appeal this, but so easy to refile and just follow the requirements this time. To be honest, most attorneys, they often prefer to refile, but it's always very much case specific. It's always better to avoid this situation altogether. That's why our motto is always do this right and on the first try. Do you have any marriage green card questions? Drop them in the comments for us to address. Make sure to like this video and we will see you next week.